The top story of this segment, however, is related to a segment we did Tuesday night. On Tuesday night, John Sullivan of the Civil Justice Association of California came on to talk about SB 1281. This is a bill that is meant to further encourage businesses and building owners to install automatic external defibrillators, or called AEDs. They're lifesavers that administer an electric shock to the chest wall to the heart after someone suffers cardiac arrest. Now, leading the push for this bill was Dr. James Dunford, the medical director of the city of San Diego and a professor in the Department of Emergency Medicine at UCSD. Well, my guest, John Sullivan, said that the measure died solely because trial lawyers opposed it because of its limited liability provisions that, John Sullivan said, would make it more difficult for trial lawyers to sue folks if something went wrong after these defibrillators were used. This led to a sharp comeback from the consumer attorneys of California, who have arranged for Tim Blood, a San Diego attorney, to join me. Tim, welcome. It's good to have you on KOGO. Now, what's the main problem with John Sullivan's argument that your opposition to this could cost folks lives? If we do want to encourage the use of these devices, why wouldn't limiting legal liability be a proper thing to do?
Hi, Chris. Thanks for having me on.
Sure.
Existing law already limits legal liability. It provides immunity to anybody who operates an AED. So if you use it and you do something wrong when you're using it, you can't be sued. It immunizes the company or the building or the sports arena or whatever that installs an AED, as long as they follow maintenance procedures and have people that are trained to use it. And that's critical, because what that does is that incentivizes people who put up AEDs, which I think are a fabulous, fabulous device, to make sure that they're not just a box on the wall that gives people a false sense of security, but at the time that you need it, you have two things, because just putting it there isn't enough. You have a machine that works, and it's operated by somebody who knows how to use it, and that's what saves lives. What costs lives in this situation is if somebody thinks that they have an AED that's going to work, and then they go and they grab it, and they either don't know how to use it, or they grab it and they know how to use it, but the thing isn't operating properly. That costs valuable time in saving that person's life. So all existing law does is say, if you follow the rules, it's like a fire extinguisher, fire codes that are prevalent all over the country. If you follow the fire codes, you're fine. But if you don't, then you can be held liable, which is a pretty fair law. To strip away that immunity, that doesn't encourage the use of AEDs or encourage the spread of AEDs. What that does is it encourages irresponsible corporations to not maintain them and not to train people to use them.
Now, Senator Alex Padilla was the introducer of the bill. It's kind of unusual in that he's a Democrat from Pacoima, and Democrats are generally thought to be associated with trial lawyer groups, but he said that even if people aren't trained, the devices are nearly foolproof and they aren't likely to hurt anyone, since the patient is almost certainly going to die without one. So that seems like a pretty powerful counter-argument that the misuse of these things, the downside is limited, given that if you do not get good care quickly, if you do not use the defibrillator quickly, the person's going to die anyway.
Well, I have a great deal of respect for Senator Padilla. I think he is overall a great senator. The problem with his argument is that the American Heart Association and the American Red Cross disagree with him. They say that people need to be trained to use these devices. And, a funny thing happened up there when the folks were going around showing senators how easy these things were to use. Some of the untrained people who tried to get it to work in just a sample couldn't get it to work because they are a little tricky. They are kind of difficult to use. And so if you have somebody who doesn't know how to use them, using it incorrectly, it's not going to save anybody's life. But it gives people a false sense of security that could cost lives.
This is Top Story on AM 600 KOGO, San Diego's news and talk station. I'm Chris Reed of the Union Tribune editorial board, and I'm pleased to be joined by Tim Blood, a San Diego lawyer who was sent our way by the Consumer Attorneys of California. Now, Tim, I hope you don't mind if we talk about broader issues involving trial lawyers, since you may be only the third or fourth trial lawyer I've had on the 6 months I've had the show, and there's lots of interesting issues. Now, I absolutely get the idea that trial lawyers, in certain senses, are fighting for the public and that they are doing good work because they are holding people accountable. But it seems to me that you folks also have a whole lot to own up to in really profound ways, and you don't ever do it. And I'll offer a personal example. I own a Ford Explorer, and several years ago I was notified that I was part of a class action lawsuit. And as part of the class action lawsuit, I ended up getting a $250 certificate for a reduction off the MSRP for a purchase of a new Ford. Given that the manufacturer's standard or retail price is a fiction anyway, it's just a starting point of haggling back and forth, this was worthless. What Ford ended up getting was essentially a marketing incentive break by creating the idea that among former Ford customers that they would get a break for this. And yet the San Francisco attorney that was handling this case, I think, got something like $25 million. So I look at that and say, what's going on here? How can trial lawyers, allow class action suits so often to end up with settlements in which consumers get almost nothing and trial lawyers get millions?
Well, I don't think coupon settlements are generally very good settlements at all. And what happened in the Ford case, from what I understand, I wasn't involved in the case, was they were all set to go to trial because Ford was going to fight it tooth and nail. The problem was, as you may recall, Ford was about to go under financially, which would have caused thousands and thousands of jobs and worsened an economy that at that time was already starting to go down. And that would have been a very bad thing. So what the judge did was brokered a settlement, and that's the settlement that they ended up with, and it was intended to be a win-win settlement. Now, I wasn't personally involved in that case, so I don't know all the details or how good the coupon was. The coupon may have actually been more useful than what you're suggesting than just simply off the MSRP. But this was a judge who is a well-respected judge who approved that settlement, and class action settlements have to be actually approved by courts. And usually they have good reasons that may not be obvious to everybody. And personally, I think more sunshine is better than less, because I think it is important for people to know why settlements like that occurred. Because there probably are good reasons for it. Not always, in any industry, in any group, there's bad apples. But overall, I'm very proud of what I do and the people I do it with.
Now, I'd like to bring up the Trevor Law case, and I have talked to some attorneys in the past, and they said, well, it's not fair to bring up Trevor Law because Trevor Law was so extreme. But in fact, you continue to see plaintiffs' lawyers arguing that they should be able to have what's called private attorney general status, in which they sue companies and organizations for not living up to the letter of state laws. And so if you're continuing to try to seek measures that give you private attorney general powers, such as AB 989, it seems to me to be completely fair to bring up the Trevor Law Group case. The Trevor Law Group was a Beverly Hills firm that went after small businesses for technical violations of state rules and often settled for a few $1,000s, and they often targeted folks with limited command of English. And when this first came up, Attorney General Bill Lockyer himself, a powerful supporter of trial lawyers, likened this to extortion. And so did a lot of folks. But in the end, the legislature did not approve any reforms of any kind. They were only imposed by voters. So I wonder, why weren't the trial lawyers of California up in arms over Trevor's excesses? And instead of saying, quietly behind the scenes, don't change any laws, they may have done wrong, but we still like the system overall as it is. Trevor
Law Group, I talk about that situation all the time because I think it's absolutely abusive, and and I talk to other plaintiffs' lawyers about that because I want to make sure that we police ourselves because we're in a great position to do it, and I think that happens all the time. Consumer Attorneys of California, I was one of the lawyers that actually went up and met with Bill Lockyer, part of a whole coalition of people who strategized about ways to stop the Trevor Law Group and other law firms that were doing the same kind of things. There were like 2 or 3 other law firms that were doing it. Not a whole lot of lawyers, but it was abusive and it needed to be stopped. And those guys ended up, they got what came due. I mean, they got disbarred, they got thrown out of the profession, and that's a good thing. I'm all for that. Now, one of the problems with the ballot initiative that passed is it goes too far. I've been doing those 17-200 cases, they're called, the private attorney general cases, for quite a number of years. They're a great tool when used by responsible attorneys, and I think most of the lawyers that used that private attorney general law used it wisely and used it fairly. And courts also look askance at abusive lawsuits. They don't tolerate that kind of stuff. So I'm all for that. The problem with the ballot initiative is it goes too far because it gets rid of meritorious lawsuits and really has created a significant hole in the consumer protection laws of California.
Tim, thank you very much for coming on. I really appreciate it.
Thank you, Chris.